This video focuses on another piece of critical legislation that dealt with civil rights in the area of racial discrimination, and that's the 1965 Voting Rights Act. So, again, there was a tremendous amount of pressure from civil rights organizations, from Dr. King, basically protesting against many of the barriers to African American voting that existed from the 1860s all the way through the 1960s. One of the pivotal marches was the Selma Voting Rights March in March of 1965 that was led by Dr. King and a young student organizer named John Lewis, who would then later become Congressman Lewis, who was a longtime representative from the Atlanta, Georgia area. Initially, this voting rights march was planned to march over a period of 4 or 5 days from Selma, Alabama, to the capital of Alabama, which is Montgomery, initially crossing over the Edmund Pettus Bridge out of Selma along Route 80 towards the capital of Montgomery. The first initial march on March 7th was blocked by local state troopers that met these nonviolent protesters with the use of physical force. This became known as Bloody Sunday, and the march was essentially forced to end. After a tremendous amount of media coverage and pressure on the government, the marchers were able to secure a permit to march again later that month, the 21st to the 25th, and they led a successful march to the Capitol steps in which Dr. King gave a speech that criticized Alabama and other southern states for their denial of the right to vote for African Americans. This march and others like it put a tremendous amount of pressure again on Congress and President Lyndon Johnson to pass legislation that would remedy the issue. And the legislation this time is the Voting Rights Act of 1965, which abolished all remaining voting barriers. Remember, the 24th Amendment ends the poll tax, but the other elements like literacy tests, voting barriers like the vouchers and the grandfather clauses are basically removed by the 1965 Voting Rights Act. The other thing that it does is establish what's called preclearance for the future. What it does is the law attempts to identify counties, which if you look over on the map are shaded in red. These are counties that had a history of discrimination against minority voters. Basically, what they did was they looked at the number of minorities present within the county, and the number of minorities who were actually voting. And if there was a large disparity between the two numbers, the county was basically shaded in red and put on this preclearance list. Basically, what this meant is that any changes that would be made to voting in the future would have to be cleared with the United States Department of Justice first. So if you look at Montgomery County in Pennsylvania, it's not shaded red. If Montgomery County wants to change the voting machines it uses or the locations of where polling places are utilized, they don't need to get preclearance from the Department of Justice first. But if Shelby County in Alabama wants to make those changes as late as 2013, they would have to get permission from the federal government first to make sure that they were not going back to using tricks to discriminate against minority voters. So this idea of preclearance lasts from 1965 all the way to 2013. It ends in a case of, again, Shelby County, Alabama, sues Eric Holder, who is the leader of the Department of Justice at the time. He's the Attorney General. And Shelby County's argument is that preclearance is no longer necessary in 2013, that they don't have a minority voting problem. Right? The Supreme Court basically agrees, and what this does, it strikes down the part of the 1965 Voting Rights Act that required preclearance up to this time. Ruth Bader Ginsburg, who is one of the justices on the for side that dissents, she basically criticizes the decision of the majority and basically says that it's foolish to think that there is no longer a problem in counties like Shelby County. That the only reason that there isn't a minority voting problem is because of the impact of the 65 Voting Rights Act and the need for Southern counties to get preclearance. Her argument, her analogy is that in a rainstorm, you don't throw away the umbrella because you're not getting wet, right? That you're not getting wet because of the umbrella. And that's her argument about the Voting Rights Act. Like, you don't toss out the part of the Voting Rights Act that helps minority voters just because minority voters are voting. They're voting because of the continued existence of the Voting Rights Act, right, and the necessity of preclearance. But from a legal standpoint, the Supreme Court ends all remaining elements of preclearance that are required after 2013.